And we are live here. We have some breaking news. It's not the breaking news that I thought we were going to get, which we will probably get next Thursday. Then probably the Thursday after we'll get more breaking news. So every Thursday is going to be kind of busy around here, and I'll be in Iceland for one of them. So got to work that one out. Not really sure how, but we'll work it out indeed. Today I'm joined by our esteemed colleagues, Flying Rich. I thought you were going to put that up on your Rumble channel too.
Oh, whatever.
You can do it. You hit edit and you just add source.
Yeah, but I got to create the Rumble stream first, so.
Oh, okay.
Just for convenience.
Okay. Yeah, I thought you already had it created for some reason. Yeah, I looked forward into it. Okay, so yeah, I know that Jared is talking about it. I was reading through it, and I have the actual ruling here. We're gonna go over it, and if you guys don't know who these guys are, this is Flying Rich, which you guys probably know, and DLD After Dark. And a quick announcement: we will be at least I will be at goals. I think Rich is going to be at goals. Dark, I'm not sure if you're going to be at goals or not.
Yeah, I'll figure it out by the end of this week, tomorrow.
Yeah. So we'll know something soon. But yep,
like me and my Geisley build.
I'll be down in goals. I'll be at the JSD booth for a little bit, and also or getting an optics booth or PR whatever booth they have. All those guys, the whole entire Jordan Company booth for a little bit, and also the Fat Tech booth. And I hope to see you guys out there. It's going to be a fun time. But let's get into what's going on. As we know, the pistol brace rule has been blocked by a permanent injunction for a preliminary injunction for a while. In multiple cases, and now it has been vacated by the district court, which is a lot more powerful than an injunction because it is done at the district court level. We're going to go ahead and read through the order here. It's a fairly short order. It's 12 pages long, and this is in Mock v. Garland, which is the FPC case, but it also applies to a bunch of other cases as well. So I'm going to go ahead and share my screen, and we can jump right into it. I'm going to kick it off with Flying Rich, who's going to start reading, and then I'll kick it over to Dark.
Well, okay then.
So, yep, you already collected it. All right, go ahead.
Pending before the court are plaintiff's motion, summary judgment, and brief support. Filed November, defendants cross motion for summary judgment and brief in support. I'm going to skip through that. Having carefully considered the briefing and applicable law, plaintiff's motion is, block letters, granted, and defendant's motion is denied for the reasons herein. Background. At this point, statutory and regulatory background is well known, and the court will not repeat it here. Go F yourself. Thus, the following brief recitation of the relevant procedural history in this case. This case was filed January 31st, 2023, in a series of cases challenging the final rule, which inter alia announces when a device marketed as a stapling brace turns a pistol or handgun into a rifle. Plaintiffs filed this suit alleging various statutory deficiencies with the process and substance of the final rule. Additionally, plaintiffs brought constitutional challenges. 3 weeks later, on February 21, 2023, plaintiffs moved the court for preliminary injunction against the defendant's enforcement of the final rule, CUSC blah, On March 30th, 2023, the court denied the plaintiff's motion for preliminary injunction on the grounds the plaintiffs had failed to demonstrate substantial likelihood of success on the merits of any of their claims. See mock and revised and
Yeah,
remanded.
like originally the case, I think it was like filed as quick as possible, so there was a lot of stuff that wasn't checked. But then they went
So
back.
this is an interesting case. Basically, they're saying it's thrown out, but initially they're saying, "Hey, we're not going to, give a preliminary injunction
Yeah,
because you
it says
filed
if
bad
you
paperwork."
yeah if you read the case, I mean it wasn't a well reasoned brief, but then they went back and they fixed it and actually presented a well reasoned brief.
Gotcha. On August 1st, 2023, the United States Court of Appeals for Fifth Circuit reversed the court's order denying preliminary injunction and decided in favor of the plaintiff's Logical Outgrowth Administrative Procedure Act APA claim that, one, it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule, and the monumental error was procedural, and the final rule, therefore, must be set aside as unlawful.
Okay, let me just explain that. Basically, what the ATF did is they put out a proposed rule to the Federal Registry, where they got a bunch of comments on, the public comment period. Well, and the rule that they put out in the Federal Registry, you had stuff like the Form 4999 and stuff like that. When the final rule was unveiled, it looked drastically different from the proposed rule. So all those comments that people made um, during the comment period were invalid because they were commenting on things on a rule that basically turned out to be totally different
bait and
from
switch.
the rule that was presented. So no one really had a chance to go ahead and actually, have comments on the rule that was posted. The ATF claimed that, hey, it was a logical outgrowth, which means we took the comments and we changed it a little bit, but it's basically the same rule with just a little bit of tweaks. Firearms Policy Coalition, in this case, and a lot of other cases, said, wait, this is a totally different rule. This isn't an outgrowth. This is another rule. This isn't the same that you did. It has no resemblance to the rule that you asked for comments on, and yet you're saying that it's a logical outgrowth. What the judge is saying is that he agrees with FPC, and this is not a logical outgrowth of this at all.
Okay. So
I hope that
providing
clears
that
up a little bit of stuff.
providing that a final rule adopted by the agency must be a logical outgrowth of its concomitant proposed rule, directing and reviewing courts to hold unlawful and set aside agency rules found to be without observance of procedure required by law. The Fifth Circuit remanded the case back to this court with instructions to assess the remaining preliminary injunction factors and rule on plaintiff's motion in light of circuit panel's decision within 60 days.
All right, let's go down to the legal standing. Dark, take this over, buddy.
In a case challenging an agency, I'm just kidding. Sorry. Challenging an agency action under the APA, summary judgment serves as the mechanism for deciding whether the action is supported by the administrative record. My night vision just fell. And otherwise consistent with the APA standard of review. Then it cites case law. The agency resolves factual issues to arrive at a decision that is supported by the administrative record, and the district court applies the APA standards of review to determine whether, as a matter of law, quote, the evidence in the administrative record permitted the agency to make the decision it did. Then it cites more case law. Skipping that. The entire case is thus a question of law, with the district court sitting as an appellate tribunal. In their motion for summary judgment, Plaintiffs claim that the final rule violated the APA's procedural requirements because, one, it was not a logical outgrowth of the proposed rule, as John had explained. Two, defendants acted arbitrarily when they failed to consider important aspects of the problems presented and caused by the final rule. And
Basically,
three,
what they did is, let me just call it. Basically, what they did is the ATF. There was major issues with the final rule, and the ATF basically just said, whatever." So the issue of people having to register, millions of people becoming felons, such and that, and the ATF just totally blew that off.
yeah. Three, defendants impermissibly extend their statutory authority under the National Firearms Act of 1934 and the Gun Control Act of 1968. And four, it violates various aspects of the United States Constitution.
Okay, basically what they're saying is that the ATF tried to make a de facto law and expanded on what the law said. The ATF is not there to make laws, it is there to enforce laws. And in this case, it seems like they took a law and they expanded what that law said to meet what their political goals, which you cannot do because only Congress can make laws.
Mm-hmm.
All right.
Additionally, and in the alternative, plaintiffs argue that if the court were to find that the final rule was properly promulgated under the APA, then the NFA's
Onerous.
And a historical regulation of short-barreled rifles, SBRs, which are commonly possessed by law-abiding individuals for lawful purposes, violates the Second Amendment. Facts. In their cross motion for summary judgment, defendants first claim that the injunctive relief sought by plaintiffs is barred by the tax Anti-Injunction Act because that relief that would obstruct the assessment and collection of the NFA's tax defendants.
Okay, let me explain what that means.
Mhm.
Basically, you have the Tax Anti-Injunction Act, which means you can't put an injunction on the tax. They're saying that since we're converting these formerly known pistols into SBRs, there is a tax on that. So therefore, you cannot issue a injunction against that because it deals with the tax. Of course, they want their money,
Of course, but also they tried to claim the same thing in the rare breed situation, but they wouldn't have received tax money for any of them because they would all be post 86 machine guns. They try to play every card they can.
Yeah, well, they also said that that there was a tax forbearance, and remember, forbearance is different from a forgiveness, and they were playing into that. But forbearance means that the tax is still there. It's just that they're not going to collect.
Yeah.
So they were trying to use that to their advantage here by saying, "Oh no, the tax is still there. We're just not collecting it." So therefore, it falls into that. So
we pinky promise we'll never come back to collect it.
Yeah.
Defendants also argue that they are entitled to the summary judgment because the final rule was properly promulgated under the APA and does not violate the Constitution.
What they're talking about is posting it to the Federal Registry for a comment period.
Yeah. Before addressing the merits, the court will begin whether the AIA applies to plaintiffs' claims. Bazinga.
All right, Rich, go ahead.
Oh, hold on. Got to change my screen here.
All right, Dark, go ahead.
The A, you want to go? You want me to go?
I'll go. The AIA provides that generally no suit for the purpose of restraining the assessments for collection of any tax shall be maintained in any court by any person, whether or not such person is the person against whom the tax was assessed. The broad and mandatory language protects the government's ability to collect a consistent stream of revenue by barring litigation to enjoin otherwise obstruct tax collection. Consistent with this protective purpose, the Fifth Circuit has interrupted the Act broadly to apply not only to the assessment and collection of taxes, but also to the activities which are intended or may culminate in tax assessment or collection, like suits to restrain the collection of information that would aid in the assessment of taxes. Holy cow.
All right, keep on going.
Defendants argue that the AIA bars plaintiffs' claims to the extent they seek to restrain the NFA's enforcement against brace-equipped pistols because an injunction prohibiting enforcement of the NFA's registration requirement would thus indisputably restrain the collection of information that would aid in the assessment of taxes. And plaintiffs' proposed injunction would stop the collection of NFA's tax. The court notes that the defendants do not and cannot claim the plaintiff's procedural and constitutional challenges to the final rule are barred by the AIA. Rather, as evidence by their arguments, defendants challenge plaintiffs' ability to seek preemptive injunctive relief. There are meaningful differences between an injunction, which is a drastic and extraordinary remedy, in Vacatur, which is less drastic remedy, Monsanto v. whatever, according because, as discussed below, the court's vacating the final rule is not granting the plaintiff's request for a permanent injunction. Defendants' argument are moot, and the court need not address whether the request of injunctive relief is barred by the AIA. Whoa,
Basically,
what did that
what
mean?
they're saying is we're not giving a permanent injunction. We're just we're vacating the rule.
Did they just say
Therefore,
that?
Gangster.
therefore, you don't have standing because that only covers permanent injunctions. We're not even dealing with that. We're dealing with a motion for summary judgment.
The final rule violated the APA's procedural requirements. The final rule was not a logical outgrowth of the proposed rule. Defendants argue that the court should use this discretion to reconsider the plaintiff's logical outgrowth argument despite the Fifth Circuit's opinion in this case.
Remember, the
Specifically-
Fifth Circuit. Hold on. The Fifth Circuit, when they appealed the preliminary injunction, said it agreed with the district court saying this is not a logical outgrowth. So then they went back to the district court and said, we want summary judgment because this is a logical outgrowth, even though the district court already said it's not. And also the circuit court said it's not.
Specifically, defendants assert that it would be proper for the court to make its own determination on the issue because this court is not bound by the Fifth Circuit's opinion. The briefing was sufficient at the appellate level, and the panel created new legal tests for determining whether the rule insufficient. Okay, sorry. Whether the rule is legislative.
There you go.
The
Dark
court
go ahead.
declined. Oh,
The court declines to relitigate a determination made by the Fifth Circuit in this case, even assuming that this court is not bound by the majority's opinion, and that the majority created a new test for determining whether a rule is legislative in nature. The court has previously adopted the majority's conclusion as its own. It cites case law.
So basically, it's saying, assuming that they're not bound by it, we actually adopted the majority's conclusion. We came to the same conclusion as the Fifth anyway. So what the hell are you talking about?
Yeah. The court. I'll go up one more.
No, sorry. Well, this is all case law.
The court wholesale adopts the conclusion as its own. Oh, okay. Furthermore, while defendants argue that the briefing was insufficient for the Fifth Circuit to make a determination, the majority devoted a large portion of their opinion to the issue. At the conclusion of the majority's careful analysis, they held that the final rule is properly characterized as a legislative rule and
a law, basically.
Mhm. Yeah, which typically you need an act of Congress or like actual legislation.
Yeah.
And it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule. Therefore, the final rule must be set aside as unlawful, yes, or otherwise remanded for appropriate remediation. Here, the court declines defendants' invitation to relitigate the issue and, once again, adopts the majority's well-reasoned conclusion as its own. Consequently, the court finds that the final rule violated the APA's procedural requirements because it was not a logical outgrowth of the proposed rule. Accordingly, plaintiff's motion for summary judgment is granted, and defendant's motion for summary judgment is denied.
If I had my soundboard here where I am, I would play the clapping, but I don't have it, so.
Yeah. We could just, pretend. Yeah,
There you
go.
All right.
Next.
Rich, go.
The court turns to plaintiff's argument that the adaptation of the final rule was arbitrary and capricious. Section 706 of the APA provides that reviewing courts must set aside agency action found to be arbitrary and capricious, an abuse of discretion or otherwise not in accordance with the law. Arbitrary and capricious review focuses on whether an agency articulated a rational connection between the facts and found that the decision was made. ExxonMobil pipeline.
You don't have to.
Okay. An agency must provide more detailed justification for a new policy that rests upon factual findings that contradict those which underlay its prior policy, or when prior policy has engaged in serious reliance interests that must be taken into account. FCC versus Fox. Plaintiffs contend that the adaptation of the rule was arbitrary and capricious for 3 reasons. The agencies failed to consider comments, concerns, reversed a long-standing position without meaningful explanation, and drafted a rule with vague standards. In contrast, defendants assert that none of plaintiffs' stated reasons are sufficient to invalidate the final rule on its face. The court finds that the adaptation of the final rule was arbitrary and capricious for 2 reasons. First, the defendants did not provide detailed justification for their reversal of the agency's longstanding position. And second, the final rule standards are impermissibly vague.
Yeah, they never said why they needed to change the rule, and that is a big no-no. And also, it was impermissibly vague because there was no set standard. It was just so, like, anything could be a short barrel rifle, basically, because there's no hard data. It was all, it when you see it type of thing here. Keep on going, Rich.
Let's see. Capricious. For close to a decade, the ATF concluded that attaching a brace to a firearm does not alter the classification of the firearm subject to the firearm to NFA control. The ATF changed course in this position for the first time in 2023 when it issued the rule reversing the agency's otherwise longstanding policy. When an agency changes course, as the ATF did here, it must be cognizant that longstanding policies may have engendered serious reliance interests that must be taken into account. Let's see. It would be arbitrary and capricious to ignore matters, but this is exactly what defendants did when they inexplicably and fundamentally switched their position on stabilizing braces without providing sufficient explanations and notice. Under the final rule,
hold on, because the president says, "Hey, change this," that's not a good enough reason. They have to say what the actual reasoning is, not, "Oh, Biden wanted this rule to be changed, so we changed it." That does not fly. They actually have to give a reason why it needs to be changed.
So I have some concern about the minutia on this, that they're not saying, "Hey, it's stupid, that's wrong, Second Amendment, hands off." They're saying, "Well, because you didn't do it." This seems like
it never rises to the Second Amendment issue because it's already been denied. Once you reach a point of being able to issue summary judgment, I mean, there could be other reasons too, but keep on reading.
But it seems to me like that the ATF can go back to the well, say, "Hey, we want to make pistol braces, short-barreled rifles. This is our new rule."
Yeah, they're not going to do that. But keep on reading.
Okay. Under the final rule, the ATF estimated about 99% of the pistols with stabilizing braces would be reclassified as NFA rifles. The ATF contemporaneously issued approximately 60 why can't I say that word? Adjudications pursuant to the final rule that reclassified different configurations of firearms with stabilizing braces as NFA rifles. The ATF provided no explanations for how the agency came to these classifications, and there is no meaningful clarity about what constitutes an impermissible stabilizing brace. The fact the Fifth Circuit could not find a single given example of a pistol with a stabilizing brace that would constitute an NFA example of a braced pistol.
Yeah, they
Unexplained.
were asked specifically to give an example, and they're like, there could be one, but we just don't know.
That sounds like firearms unknown. Such unexplained and inconsistent positions are arbitrary and capricious, quoting blah. The defendant's disregard for the principles of fair notice and consideration of reliance interest is further exasperated by its failure to follow the APA's procedural requirements for public notice and comment. As discussed above, defendants failed to follow proper notice and comment procedures because the proposed rule and final rule differed in immense ways.
Yeah, basically it was totally different. We're gonna skip a bunch of this because it's just gonna harp on that for a little bit. Now go over to moreover. Dark.
Moreover, the court finds that the standard. I knew you were going to do that.
Dark, go.
Moreover, by the way, I'm always LARPing for those in the chat. Moreover, the court finds that the standards set forth in the final rule are impermissibly vague. While the worksheet in the proposed rule would allow, quote, an individual to analyze his own weapon, I don't like that it's called a weapon, but whatever, and gave each individual an objective basis to disagree with the ATF's determinations, the final rule vests the ATF with complete discretion to use a subjective balancing test to weigh 6 opaque factors on an invisible scale. Dang.
Yeah, it was an invisible scale. I mean, nobody knew what the hell it meant.
That's what they wanted. Consequently, the court finds that the final rule's 6-factor test is so impermissibly vague that it provides no meaningful clarity about what constitutes an impermissible stabilizing brace, and thus that, quote, it is nigh impossible for a regular citizen to determine what constitutes a braced pistol that requires an NFA registration. Accordingly, plaintiff's motion for summary judgment is granted, and defendant's motion for summary judgment is denied.
Because they basically said we're not banning all pistol foot braces. They're like, well, how do I know if mine needs one? They're like, we'll let you know.
We'll be good about it.
No, we'll let you know, and if it is, we're going to charge you with a violation of NFA, which can put you in prison for 10 years and fine you $250,000. But you know, you can you're free to take your chances, though.
Yeah.
All right, go ahead. Keep on reading, Dark.
You'll know when you see it. There exists an ordinary rule that a federal court should not decide federal constitutional questions where a dispositive non-constitutional ground is available. If there is one doctrine more deep, that's case law, right? Or no, sorry. If there is one doctrine more deeply rooted than any other in the process of constitutional adjudication, it is that we ought not to pass on questions of constitutionality unless such adjudication is unavoidable. Before deciding the constitutional question, it was incumbent on the lower courts to consider whether the statutory grounds might be dispositive, cleaned up, I guess. Thus, if a case raises both statutory and constitutional questions, the inquiry should focus initially on the statutory questions. If the lower court...
Okay, stop right there. Remember what I was taught when you asked about the constitutional thing?
Yeah.
Rich
just
I kind of explained. There you go.
If the lower court finds that statutory grounds dispositive, resolution of the constitutional issue will be obviated.
Yeah, so there's no need.
Moreover, the Supreme Court has encouraged lower courts to avoid expanding scarce judicial resources to resolve difficult and novel questions of statutory interpretation that will have no effect on the outcome of the case. Because, as discussed above, the court finds that defendants' adoption of the final rule violated the APA's procedural requirements and that those claims are dispositive. The court declines to address the constitutional questions presented, as well as the question of whether defendants exceeded their statutory authority in interpreting rifle under the NFA and GCA.
Basically, what they're saying there is, hey, we already found that they violated the APA, so there's no need to go further.
Because otherwise, this could have been used as precedents to attack the NFA, SBRs, right?
Well, not only that, it's more of, the courts want to get in there, rule on something quickly. So if they already define that, it violates the APA, which you do before you go to constitutionality, you go to the statutory, right? So if you find enough evidence to decide for a motion for summary judgment for the plaintiff, then there's no reason to go further because that summary judgment is already there. So it's just, it'd be more work for nothing because you're not going to get any more out of it. I hope that makes sense. But if they failed on the APA challenge, then it will go to the constitutionality challenge, which it didn't have to do because the plaintiffs proved their case when it came to the APA.
Got it. Finally,
all right, Rich, go take it from there.
Okay.
Finally, the court turns to what appropriate remedy is in this case. Plaintiffs request the court vacate the final rule in its entirety and grant permanent injunction enjoining defendants from implementing, enforcing, otherwise applying the final rule. In response, defendants argue that the court should not vacate the final rule as there are more limited remedies that would redress the plaintiff's injuries. Additionally, the defendants claim that the court should deny the requested injunction because plaintiffs have failed to carry their burden on the request. I'm sorry. This is the best comedy.
Dark, take over.
Okay, where did you leave off? I couldn't
the proper remedy.
The proper remedy for a finding that an agency failed to comply with the APA's procedural requirements is vacatur of the unlawful agency action. While defendants are correct that the APA does not require such a remedy, the Fifth Circuit considers vacatur?
No,
whatever. The default rule for agency action otherwise found to be unlawful. And then in ASLITA case law.
Go down to here where it says in rare cases.
There we go. In rare cases, however, we do not vacate the action, but instead remand for the agency to correct its errors. Whether remand without vacatur is the appropriate remedy turns on two factors. One, the seriousness of the deficiencies of the action, that is, how likely it is the agency will be able to justify its decision on remand, and two, the disruptive consequences of vacatur.
So they can basically say go back and clean this up a little bit, or they can just say throw it out. And in this case, they said throw it out. So I keep on going, Dark.
In this case, vacatur is appropriate given the court's conclusion that defendants' adoption of the final rule violated the APA's procedural requirements. An illegitimate agency, that's perfect for the ATF, action is void and therefore cannot be remanded as there is nothing for the agency to justify. Further, applying the vacator of the final rule to only plaintiffs is more akin to an injunction that would prohibit defendants from enforcing its unlawful final rule against only certain individuals. And indeed, there are meaningful differences between an injunction, which is a drastic and extraordinary remedy, and vacator, which is a less drastic remedy.
Okay, what the ATF was trying to say is, hey, if we do lose this case, what we want you to do is basically either let us go back and fix the errors that you guys find, or you can apply an injunction, but only to those named in the case, not everyone.
This is because vacator does nothing but reestablish the status quo that existed for decades prior to the final rule going into effect last year. Absent the unlawful agency action, apart from the statutory basis on which the court invalidated an agency action, vacator neither compels nor restrains further agency decision making. Because defendants fail to show that this is a rare case in which the court should deviate from the default rule, the court vacates the final rule on the grounds that defendants violated the APA's procedural requirements in promulgating it. Because courts presume that the federal government will comply with its rulings, plaintiffs requested injunctive relief is unnecessary and thus is denied.
Yeah, basically they're denying injunctive relief because they're vacating the rule.
Yeah.
So there's no reason to grant injunctive relief because you're throwing out the rule. So
Yeah.
There's nothing to add an injunction to because it's done, gone.
Yeah. Conclusion: for the reasons set out above and repeated several times, that's okay. The court grants plaintiffs' motion for summary judgment on the grounds that the final rule violated the APA's procedural requirements because it was arbitrary and capricious and was not a logical outgrowth of the proposed rule. Denies defendants' cross motion for summary judgment, denies plaintiffs' request for a permanent injunction, and vacates the final rule. Boom. So ordered this 13th day of June.
So there we go.
All right. So who is Reed O'Connor?
Reed O'Connor is a judge out of the district court. He's actually a pretty strong judge on the Second Amendment. He also did the frames and receivers, where he issued an injunction there as well.
Okay.
Incoming White House statement that the courts are broken. Right? Because you guys know that our current president said, you take a pistol stabilizing brace and you put it on and it shoots a bigger caliber bullet and like what?
And a high capacity magazine and takes satellites out of orbit.
And there was one, I think it was Jerry Nadler that said that said that
it's a bump stock.
That basically said that
makes it fully
automatic.
automatic.
Up the rate of fire, and Massey's like, no, it doesn't.
Yeah.
And they got an argument about it. But yeah, so this case is not over. It is over. Yeah. Basically, the rule is dead. It's non-existent right now. This case is going to be appealed to the Fifth Circuit Court of Appeals, where they're going to lose because they already lost once, so they'll lose again. And then it was probably heading to SCOTUS, which SCOTUS might or might not take it up. We have the Cargill case, which we should know something either next week or the week after. So within 2 weeks, we'll know about the Cargill case. And depending on where that lands, we'll know what the Supreme Court will probably do with the case. If Michael Cargill wins his case at the Supreme Court, I don't know why the ATF would go to the Supreme Court, because basically that's all about violating the APA too. And if the bump stock case violates the APA, this definitely violates the APA. So if
Mhm.
the Supreme Court finds that the bump stock rule violated the APA, they're definitely going to find this violates the APA. So it'll be just a waste of money and a waste of time for the ATF to try to fight this any further. So we'll have to see what happens with that. Also, with the cargo case, it would also give us a idea of where the Vanderstock case is going to go as well.
Yeah.
But this is a massive victory for the Second Amendment community. This is a massive victory for Americans because the ATF tried to overstep their bounds. They tried to make law that they called a rule, but was a de facto law,
Mhm.
and they just got their pee smacked.
I think it's
I would say
important.
slammed in the door hard.
Yeah, steel door. I think it's important too for all those dudes that come
Cybertruck.
in. You know,
Good.
we do shows all the time, and we're talking about things, how to become active and get involved. And there's always people that come in and they're like, you know, it's over. No more voting. Courts are broken. Yes, the system is damaged incredibly, but look what is happening.
We've been winning more than we have been losing.
Yeah.
Absolutely.
100%, 100%. That's one of the things I always talk about. If you look back since the Heller decision, Dick Heller, who's a friend of the show, the Heller debate, the rule cannot be enforced. The rule does not exist anymore.
Yeah.
But the Heller decision was in 2008 was like the first decision, and it started rolling, everything rolling. But it even goes before that. Then we had the Bruin decision, and then we have all these lowercase, the Vanderstock at the Fifth Circuit, this ruling. There's tons and tons. They engaged in the business ruling. It's very, very interesting. Brandon says we need an assault weapons ban in the case. Tune in Monday. We might get that on Monday. We should be getting a ruling whether they're going to grant a writ of certiorari on Monday. By the end of the month, we'll get a ruling. I think it's probably going to come Monday whether we get a writ of cert or not. Hopefully, we do get a writ of cert because taking out an assault weapons ban would be massive.
Yeah.
And that would be and that would be awesome, because if you go by the Bruin decision, text, tradition, and history, right? And if you look at the founding era, 1791, 1792, late 1700s, they wanted the citizenship to have military weapons, even though
every firearm was an assault weapon.
Yeah.
There were nothing else.
They wanted that. And if you look at basically, there was a case where they said, yeah, they can ban sawed-off shotguns because they don't have a military purpose.
Yeah, they totally went back and forth on that.
Yeah. So, but
it shows you what 80, 90 years can do. I mean, they've completely. I mean, they do it all the time, right? They argue to whatever serves their interest.
Correct. Whether a suppressor is a firearm or not a firearm, the ATF is arguing the same opposite things in two different courts.
Yeah. Is the suppressor a firearm? Is the suppressor a accessory? Now that's going to get that's an interesting catch-22 there with suppressors. I want to get into that a little bit.
Yep.
I make a video about that because here's the thing. If you think a suppressor is an accessory and not a arm, does it lose constitutional protection?
Yeah. Yeah, I've considered
that's something to be considered. It doesn't mean it has to be a regulated arm, because magazines are considered arms by most courts.
Wow.
Even though they are an accessory. So if you think about that, but if they decided it's not a firearm, it's not an arm, then, we might lose our protections on that. So that's just something to think about. You got to look at the whole entire situation there. But yeah, that is what is going. Is your dog's name Tanner, right?
Yes. No, that's a different dog at my front foyer.
Or go to tannerightdog.com.
Yeah.
You can't do
So,
anything
yeah.
when you get there, but
Yeah. But before we go, I do want to plug a couple things.
fat tap.
So, if you saw my channel earlier on, there was a video put up about a Minecraft server that's opening up. The reason I did that is I think we need to have more people, like-minded people like us in tech, and we need to teach our kids tech. So I've been using a Minecraft server to teach my kids tech. We've modified some of the source code and stuff like that to do stuff that it was never in Minecraft. So he's opening up a server on Saturday at 3 p.m. Eastern, 2:45 is actually when it starts. And that's at server@crumpy.com. It's a public Minecraft server, and should be a good time. And also, I want to promote a knife company that is going to launch soon.
Oh snap!
I might have a couple of the guys that own it in the chat.
Yeah. You wanna talk about it?
Well,
I mean,
so there will be definition knives and actually a trigger company. So we're going to have knives and triggers
yeah.
soon.
And just to throw this out there, where this kind of came from, and thank you, John. They're not available yet, and they will be soon. We'll let you guys know when they are, but they'll probably be for sale on DLD hardware whenever that day does come. But what we did is we were like, okay, some knives are like very cost prohibitive, like Benchmade for an example. Yo, chill. But they're great knives. So we were like, how could we get an Axis style system that would be a great EDC knife that instead of having to drop 229, 249, 279 or more, how could we, create an affordable EDC knife that's, similar to that standard, that's under $100, probably 69 to 79 depending on the steel, and have them be 8CR13 MOV steel, D2 tool steel, and they're also going to be super dope, and they're going to be named after, they're going to be like paying homage to individuals. Like for an example, there's going to be one called the Co-Pilot in honor of Flying Rich. There's going to be one called the Journalist in honor of Crump. There's going to be one called Birdshot in honor of the Tactical Turkeys. And some of the people that you guys see on GunTube, YouTube all the time, like nearly every day, there are going to be knives made and named specifically to honor them. So that's what we're working on.
You're not gonna name the Tactical Turkey's knife the testosterone.
The
Turkesterone.
the Turkesterone.
Testosterone,
Dude,
yeah.
most people, what they say that we should call it? The Gobbler. And I was like, dude, no, I know too many girls that were called gobblers, so we're not gonna do that. Yeah, so yeah, we'll figure that out. And everyone's saying like, Dark, you should do yours as like the glowy or the dark blade. I'm like, dude, I don't even know. I wouldn't know where to begin. But because my viewers and all of our viewers are so much smarter than myself, I would love to get some feedback from y'all. So yeah, check it out.
There will be a bumper sticker saying "Flying Rich is my co-pilot."
That would be cool. It's
Okay.
2024, so I don't know how many people use bumper stickers. Maybe a bumper magnet. Maybe I don't know. But
All right,
they'll be
guys.
on DLD hardware.
All right, well, that is it. I gotta get back to my day job here.
Day
You got
job.
a day job?
I have a day job, yes.
Boring.
I know.
You mean the GOA is calling?
No, that's not my day job.
Ladies and gentlemen,
I
thank
work in
you
the
so
tech
much.
field.
Thank you for coming in, tuning in, and hanging out. And I just want to show some love to John Crump. You do a lot of work, put in a lot of work into what you do. And honestly, you're just doing this on the side. You're not doing this for, money, for anything like that, for clout. It feels good when people watch you, but I'm sure. But I appreciate what you do, man. Thank you.
Crump is the
Thank
man.
you.
You've brought me back into having at least a tiny little fraction of a molecule of hope because Lord knows it's easy to lose hope in
Mhm.
our.
Mhm.
in
Well,
our-
they want you to lose hope. That's the whole entire point. They want to make you think you're losing when you're actually winning.
Very good point. Law Operators Anonymous, good to see you. Go watch his
The-
videos; they're incredible.
Yeah, the most dangerous thing facing the 2A community isn't the anti-gunners. It's none of that. It's apathy.
Mm-hmm. Mm-hmm.
Yep.
Yeah. Jared had a video on that, basically talking about how many firearms owning people are not registered to vote.
Mm,
Exactly.
yep. Yeah. Good point.
Yep.
Well, thanks again.
Exactly.
Appreciate
All
it.
right, guys. That is it. I hope you guys have a great day and stay safe.